Welcome to Lincolnshire Chamber of Commerce's first ChamberConnect virtual event. ChamberConnect is a series of interactive and virtual events covering topics to support you, your staff and your business. Our first topic is on employment law and the coronavirus, being delivered by Oliver Tasker, Wilkin Chapman and Simon Beardsley, Chief Executive of Lincolnshire Chamber of Commerce.
Before I go on to just explain a little bit more about it, what I will do is just give you some more information about what the Chamber of Commerce has been doing recently. Just spend a few seconds, because I think that's really important to tell you what we've been doing in the background. I think we'll all acknowledge that these are unprecedented times. Things are happening on a rapid basis, and we've got to adapt in terms of how we deal to situations that we would normally not think about on a day-to-day basis. So the Chamber of Commerce has been proactively trying to contact many of its members to understand what they are feeling at this particular time, what they're seeing. Right from the smallest to the largest corporates, we've tried to collect that information. So what have we done with it? Well, we've used it for our lobbying purposes. We've been talking to our colleagues at British Chambers on a daily basis, and we make sure that that information goes nationally to the government and to departments within the government that are making decisions at this stage. We've also got a local input into our local authorities and also in terms of the Greater Lincolnshire Local Enterprise Partnership as well. We've been able to provide information via our website, www.links-chamber.co.uk. If you go onto the homepage, you can't miss the big banner that says COVID-19 Hub. On there's a huge amount of information that we've been updating daily, if not hourly. If you haven't been on there so far, it's definitely a worth going to see just for the scope of the information that we've got. We are sending information proactively to our members on a regular basis, posting it on the web or via eShot. If you're not part of our LinkedIn group, I would suggest that you get connected to us there as well, as we are sending information both about these events that we're running and information as well. If you're an international trader, what we've tried to do is to move our support for documentations from the office in Lincoln, and that's been moved to remote locations. So if you are an international trader, we are still able to offer that help and support in the same number, do the same things you did before, just our colleagues are working from home. So finally, the information that we provided from members has suggested that a forum such as this would really be appropriate at this stage to quickly react to the situation, to give you information, but also to be able to allow you to participate in an event as well. In a moment, I'm going to introduce you to our key partner today, who is Oliver Tasker. Oliver is a partner at Wilkin Chapman. The first one of these seminars today or webinars is going to focus on employment law. Tomorrow we've got one with the British Business Bank. Next week we've got some more as well. And as we get towards the end of this webinar, I'll give you more information about what we're looking to do there. How this is likely to work though is that I'm going to hand over to Oliver soon. He will just give you an overview of the current situation with regard to employment law and COVID-19. We've got some pre-scripted questions that we'll then go through. Those questions will go through all sorts of areas and topics. After that, we will aim to come to you for your particular questions. And how we aim to do that is that if by the end of the questions that I go through, you haven't heard the answer that you want or an answer to an area of questions that you want to look at, either please use the text box to put them in, or raise your hand in the electronic way, certainly not physically, and then we'll try and get to as many of those questions as we can by the end. Now, at the moment, there's 200 people on this particular webinar, so it might be difficult to get around to all of those. So we have got a little save all at the end, I'll mention, in terms of if you haven't heard an answer to the area that you want, a way to actually pose some further questions and get some answers at the same time. So if we can, I'd like to just hand over to Oliver to set the scene at this stage. And if the technology is working, Ollie, are you there?
I am, yes. Hopefully everybody can hear me as well at this moment in time. It came up as a notification at the bottom, but if everybody could mute their microphones so that it doesn't interfere while we're speaking. And then, as Simon said at the end, there'll be the opportunity for Q&A, either to submit through the chat feature or to raise your hand. But that'd be very useful if you could mute your microphones at this moment in time. And I presume that everybody can hear me okay as well. Just nod if you can. Yeah, excellent, thank you very much. Thank you, Simon. So as Simon said, I'm Oliver Tasker. I'm a partner at Wilkin Chapman Solicitors. We're predominantly based in Lincolnshire and East Yorkshire. We're the largest firm in Lincolnshire and East Yorkshire. And as you can imagine, we've been absolutely inundated with inquiries, with questions from businesses for support during these unprecedented and extremely difficult times. I'm a partner, I specialise in employment law. And within the last couple of weeks, again, we've been inundated with questions to help employers. We're going to go through some of the main topics and areas that I think you'll need some guidance and some overview on, and we'll bring out a lot of the key themes during that. But like I said, you will have opportunity at the end to ask any questions that you want. Also, my details will be sent around after the webinar today. So if we didn't have a chance to answer your question, then you can ask me, and either I or a member of the team will be able to contact you with that.
Okay, so the first question I've got for you, if that's okay, is what employment law have you been giving to businesses, or employment law advice have you been giving to businesses at this time of the pandemic?
Yes. So you'll have all seen the announcement on Friday by the Chancellor, and the biggest announcement that's been made is in terms of the financial support for businesses through the Corona Job Retention Scheme, the Coronavirus Job Retention Scheme by the government. That's unprecedented, unheard of support that the government is going to provide to businesses and to employers, and really is amazing. There's lots of questions that have come out from that announcement, and we are waiting for some of the finer details, and particularly when the coronavirus bill has been received for all assent, which it has been today, yesterday, but when we get the finer details, I can go through some of the headlines with you and certainly answer a lot of your questions on the retention scheme. Part of it, you'll have heard of a new phrase as well that we're not used to in terms of UK employment law, and that is of furloughed workers, and the word furlough. So it's an American term. Very much there's no legal definition of what a furloughed worker is within the UK, and nothing within the Employment Rights Act, and certainly nothing that we are used to. What's really the scheme aimed to do? Well, it's available to all UK employers, not local authorities or public sector though, so private sector we're looking at. HMRC will reimburse 80% of a furloughed worker's wage costs up to a cap of £2,500 a month. That's the headline, and that really is unprecedented support that businesses are receiving from the government. Now, there's many questions that come out of that. The first one is, well, how is this scheme actually accessed by businesses? And really, the first step is for businesses to determine who they are going to designate as these furloughed workers. Now, the overall thinking behind this scheme is that HMRC will reimburse the salary costs for those employees that otherwise would have been laid off due to this crisis that we're facing. And that's really an important point that needs to be made. So technically it's not there to top up people's salaries that may be at home due to sickness or self-isolation. It is purely there to support the employees that would have otherwise been laid off, made redundant, lost their job because of the crisis. So that's the first important point to note. So if it's the case that the business doesn't have sufficient work for workers and wants to send them home, they will need to designate employees as a furloughed worker and notify the employee of this change. Now, if the employment contract, the contract of employment, has a layoff clause or short-time working clause, what that means is that you've got the contractual right as a business to send that individual home because you do not have work for them to do during that week. And again, if you have a layoff clause, there's no contractual right to be paid during that period. If that's the case, then you can nominate and designate employees by utilising that clause. Now, most businesses at the moment probably don't have layoff or short-time working clauses within their contract of employment. So you won't, as a business, be able to strictly rely upon that. So if you are under the circumstance that you don't have sufficient work for the staff, then you'll need to gain their agreement for them to to become a designated furloughed worker, and that will come about through conversation. Now, really, the idea behind the scheme is to keep people's jobs open for hopefully when businesses get through to the other side of the crisis. Now, if you're presenting to an employee that unfortunately you're going to have to utilise this scheme because you don't have sufficient work and you're looking to gain their agreement, in all likelihood they are going to agree to it, because the alternative is that either they'll be laid off, placed on layoff, placed on short-term working, in which their pay is also reduced, or unfortunately they may be made redundant. And in these times, businesses aren't getting the cash in that they would expect, and an employee may not receive the notice pay up to date, the statutory redundancy pay. So if you are saying to them, we want you to remain at home and you will receive 80% of your pay, you'd anticipate that those individuals will agree to it. What needs to happen as well is when an employee has been designated as a furloughed worker, the business will need to submit details to HMRC using an online portal, A, confirm which individuals have been designated, and B, to confirm their salary details. Now, a big question that we've got at the moment that we need further clarification on is that we don't actually have the portal set up, and we don't know when HMRC will do that. It is looking likely, someone said by the end of April, so let's hope that that is the case. The other point to note is that the scheme is initially open for a period of 3 months. So that you can get the reimbursement for the wages for that 3-month period, backdated to the 1st of March. Now, what the government has said is that if the need is there, they'll extend that, but at the moment it is for that initial 3-month period in time. I mean, that may cause cash flow issues for businesses that cannot afford to pay salary costs, wage costs, in which case there are various business interruption loans that are available from government as well under these circumstances. Another slight question that we've got at the moment that we need further clarification on is this 80% stroke cap of £2,500 per month. What does that actually include? Is that gross? Is that net? Does it include pension contributions? And does it not? And again, we need the finer details to really confirm that from the government. When you designate an employee as a furloughed worker, like I said, predominantly you're going to be seeking to get their agreement, and that needs to be confirmed in writing to them, because you will be varying their contract of employment. So you can't, as a business, place people on this furloughed worker, on the scheme. Normal principles of employment law still apply, which again you need to be conscious and wary of. Once you have agreement, you'll confirm it in writing. People sign to confirm that they agreed to become a furloughed worker, at which point they will go home. Now, the government support, HMRC will refund 80% stroke £2,500 per month as a cap. A lot of questions we are receiving is, does a business have to then top that up to 100% of pay? So do they have to cover the shortfall? And the answer to that is no, there's no obligation on them to do so. And within the letter that you are providing to that individual, you'll be making that clear. So it categorically will state you'll receive this 80% of pay, your salary will be pro rata on that basis for the time being, and we're not in a position to top you up any further than that at this moment in time. There's probably a lot of questions that you've got in terms of furloughed workers, the scheme overall. Simon, I can run through some common questions now if you want, or we can go on to the next question.
I think it's probably appropriate. I think that's got quite a few on the chat going. I think you can see the chat your end as well, can you, in terms of what people are asking? Yeah, I can. Let's see if I can access that. So just maybe I'll just pick a few off there, which may pick off a few questions as well.
Yes.
If we wanted to top up the 80%, could we use annual leave to do so?
That's quite a common question, is that can businesses during this time get people to take annual leave and annual leave during furlough worker leave? And the answer is yes, it appears so. So you could ask an employee, as you always can as a business, you can enforce annual leave at any time by giving people the amount of notice, the time that they are asking to take. So if you wanted them to take 2 weeks, technically you'd have to give 4 weeks notice. Now, under these circumstances, everyone has been working on a more pragmatic, reasonable approach. If you are saying to an employee, look, we want you to go on annual leave and you receive your normal pay during that period, so it will be topped up, and they are likely, again, to agree to that during this time.
Another one is, does furlough affect redundancy calculations?
So the 2 points from that really, so you may have people that are on furlough leave that the situation in terms of the business changes, so that you may need to start a redundancy consultation with those people on furlough leave. At the moment, there's no reason to suggest that you cannot start a redundancy consultation with those people on furlough leave. Now remember, the purpose of furlough leave is that they would have been laid off because of the crisis, the coronavirus situation. So key point is that these individuals need to be at home and doing no work. Going back to the redundancy point, you can start a redundancy consultation with them. There appears to be no reason why not, unless we receive clarification on that when the legislation is published. With the statutory redundancy payment, or with people's notice pay, it's likely that the notice pay will be at the normal rate of salary, and it's likely that the statutory redundancy pay would be calculated on the reduced pay at that time. But again, these are questions that I anticipate we'll get further guidance on when the legislation is published.
A similar one to that, maybe just to clarify the point even further. Can employees take holiday whilst on furlough?
Again, no reason why not. No, there's nothing within the guidance that's come out to date that says that they cannot take annual leave during that period. So either an employee can request, or an employer could ask employees to take annual leave as part of that furlough leave and recover up to 80% from the government.
Okay, I think we'll probably come back just looking at the time in terms of where we are. We'll also ask for participants to ask their questions directly as well, if that's okay. So just moving on to some other areas, maybe in terms of if we've got somebody at this time who refuses to come into the workplace as they're worried about the current situation, what do we do?
Yeah, so this has been a big question that's come up in previous weeks, probably really before, or as the government were putting various measures in place in order of self-isolation and protecting the vulnerable. So if you've got a normal employee that is refusing to come into the workplace because, for example, they are worried about their health, they're worried about coronavirus, they think it may be a risk coming into work, government guidance currently is that people should be working from home where they can and where it's feasible to do so. That's not possible in everybody's job. It's not possible to be at home for everybody. So businesses are staying open at this moment in time and people are going into work as normal, subject to social distancing. If somebody unreasonably refuses, technically they won't be entitled to statutory sick pay because they are not self-isolating, they've not had any symptoms of coronavirus, and they will not be entitled to full pay. Realistically, a business could say, we have work that you need to be doing, you are unreasonably refusing to come into the workplace, therefore you'll be on a period of unpaid leave at home. As harsh as that sounds, that is the legal position. Now, it's slightly different for those we've seen recently that the government will be writing to around 1.5 million people by Sunday that are classified as vulnerable or at extreme risk in terms of coronavirus and the consequences. Now, the SSP regs were amended, I'll just find the wording of it, which would cover this situation. And it states, the regulations state that SSP will be payable where an individual is isolating themselves from another in such a manner as to either prevent infection or contamination, or in accordance with guidance by Public Health England, NHS, etc. So for the 1.5 million people that receive a letter by Sunday that state you have to essentially stay at home for a period of 12 weeks, it's likely that they will be caught by SSP provisions.
Okay, another current one probably are schools, which closed for many families last week, and that's creating issues for parents. What should a business do though if they've got individuals who have family who they can't do anything with as such at home? How do they treat them when there's an opportunity, I suppose, to not be able to do all the work you could do if those children were not there in the most delicate way?
Yeah, it's a difficult situation, isn't it? Where unfortunately the schools have now closed, and that has many knock-on effects. For people that can work at home, they may be able to still work from home, albeit maybe reduced hours, slightly different working times. It's about that flexibility. For those that cannot and cannot have other childcare arrangements due to various reasons at the moment, again, anticipate that employers will predominantly be understanding during this period of time. And maybe supporting with pay. The default position legally is that it's classed as dependent care leave, which is technically unpaid.
Okay, and a question that I suppose has come up more often recently is about travelling to work. So as things have become more stringent in terms of your ability to get to work or go to work, can you give some more definition of who is allowed to travel, or are there any physical restrictions on people travelling to their place of work if they can work at that place of work?
I mean, the guidance at the moment by the government is that obviously people should be staying at home and working from home where possible. That's not an absolute must at the minute. So people can still travel to work, and there seems to be some confusion about that. People can travel to work as long as people are self-distancing. A lot of places at work will be putting in measures as well, again, social distancing within the workplace, so people can continue to travel to work if necessary, and that's also a key message from that.
Okay, so can we just discuss key workers? So is there a definition of what a key worker is?
Yeah, so key workers has been a big part that schools will stay open either for vulnerable children or the children of those key workers that can't arrange alternative care. Key workers really cover those that are within the care sector. NHS obviously workers are key to the crisis and tackling coronavirus. Where we're also seeing it locally, particularly is the food sector. And the supply chain in terms of the food industry, transport as well. That's critical in terms of keeping the country going and tackling the coronavirus that we're facing at the moment. People that work in key public services and government departments as well. Also those that perhaps are working in the sector of the supply chain for the medical sector. So we've got clients that are manufacturing products for the NHS, would be considered key workers, and predominantly around here, as I said, it's really the food industry as well. Okay, so in terms of just wrapping up our questions, I think I'm probably going to do so. There's a huge amount that's still coming through on Furlough, yes. So there's an opportunity, I think, to revisit those. I've got some hands up at the moment that I'll be going to as well. So if we haven't covered an area that you'd like to, so now is the time, participants, to put hands up, and we'll come to you very soon if you wish to participate that way. So the last question from me, is there any best advice that you could give at this stage for employers for looking after their employees that are working from home? So best practices in terms of making sure that employees are safe and have good welfare at home. Yeah, it's a good idea if you've not already as a business to have a home working policy. I've seen a lot of businesses implement those recently that perhaps had gaps or didn't have a home working policy at all, which addresses such things as the provision of equipment, IT equipment, chairs, remembering at all times that you may have employees that would be considered as disabled for the Equality Act. So again, you need to be looking at reasonable adjustments and helping with those, whether it's with equipment that they have at home or have access to, or even chairs, support in that manner, and really setting out their guidance of home working and how it will realistically work. The other thing to take into account in a more longer term approach, The retention scheme, which we're going to come on to, we'll have a lot of questions of, is at the moment only for 3 months. And it's that reimbursement, we're not sure when will actually come from the government. In the short term, that may have cash flow implications for businesses, and a lot of forecasting will have to be done to see where the business is going to be at month by month. Worst case scenario planning should probably also take place. If the government support does finish after this period of 3 months, businesses may not be in a position to have employees come back to the workplace at all, or they may know a business may not need as many employees as well. So really businesses need to be looking to plan layoffs at that point. So again, utilising any contractual clauses to say that you do not have sufficient work and they'll be at home on no pay, or short-time working, or even redundancy planning as well. So the longer-term business planning is going to be essential for that.
Okay, so I'm going to try and bring in a participant who's asked a question. So Laura Lake, you've got your hand up and I'm going to unmute you. Would you like to ask us your question?
Sorry, no, I didn't realise I had my hand up, sorry.
Well, technology works though, we know that part.
Okay, so I'm now going to pick on Kay Burge. Kay, are you there? Have you got a question?
Hello, everybody. What I would like to know is, with running a recruitment agency, I've had temporary staff that have been laid off by my clients, but I want to put them on this scheme. Is there any least amount of time they could have been on your book, so to speak? So I've got a guy who'd only actually done a week.
Yeah, two elements to that question. Firstly, is whether they would be entitled to be designated a furlough worker. So at the moment, it appears that it's only applicable to employees under the government retention scheme. Potentially, it may not cover agency workers or temps. So question mark over that. And again, we're going to get hopefully some further guidance from the government. It can happen where, say, your end user client may say, we don't need these temps anymore, in which case their assignment will end. Yes. And then it's really down to your relationship with that temp and that individual, and whether they are on PAYE or not, and whether they're an employee. So we'll get further guidance from the government on that.
Okay, thank you for your help.
No problem.
Okay, so next, Nikki Bourne, are you there?
Yes, good afternoon, everybody. Can you hear me?
Yes, we can.
Fabulous. Yeah, sorry, I sent you quite an essay of questions through. There's a couple not been answered. One of them is,
Nikki, can you hear us?
We might be able to see the question from the chat, may we?
Nikki, hi, can you hear us?
Hello?
Hello. Sorry, we lost you then. Would you just repeat your question again for us?
Yes, so my question relates to the fact that furlough is a terminology not normally used in the UK. And as such, I wondered if there's going to be any communications packs or templates being made available to help employers ensure that they adhere to the correct language and format for specific communications, such as letters to employees.
Yes, we as a business, Wilkin, Chapman, our employment team and myself, we've created documents and precedents and letters that businesses can issue to their employees. So firstly, to designate employees as a furlough worker, as you say, is not a word that we used to. It came as a surprise. Probably a government minister came up with it just before the announcement. But yes, Wilkin Chapman, we have created documents and templates. So if you want to contact me separately, then I can advise on that point. I imagine in time there may be further information as well that is available, perhaps from the government. But if you want to be acting now and making the maximum use of that 3-month period, then feel free to contact me.
I'll come back to those with the hands up in just a second. I'll just cover some more of the chat questions that have been raised. Are bank and 0 hours type contracts in scope? What about small businesses that are limited companies and the director is an employee and owner too? Is that in scope?
So the director employee, so a normal company's house director who is also an employee would be covered. Now the reimbursement of 80% up to £2,500 per month, that would cover their salary, their pay, and not dividend payment. So it may be the case that through PAYE, that HMRC, that director's actual salary payments are low historically, so only that amount would be covered, and it would not cover dividend payment. And there's a first part of that question as well, Simon, if you could repeat that.
Are bank and 0 hours type contacts in scope?
As far as we are aware, no, unless they satisfy the definition of an employee. So again, it's like the agency worker question earlier on, it doesn't appear that they will be covered. So unless the legislation, when it's published, confirms that, at the moment it's one of the questions, but it doesn't look like they'll be covered.
And it's just slightly in context with one of the questions earlier, but I'll just ask it again for clarity. If you'd offered a new starter a role and they haven't signed an employment contract, but have not started, can you class these as furloughed employees?
Potentially, yeah. If they are, say, for example, going to or due to start on the 1st of April, there's nothing to suggest yet that when it comes to that date, if you do not have work for them to be doing, it looks like you will be able to designate them as a furlough worker. Now, as a business, you may be deciding that realistically we don't need that position anymore, and therefore either you may look to withdraw a job offer if it's not been formally accepted, or alternatively, as in this case, an offer's been formally accepted, there is a contract of employment in place, therefore you will need to terminate it with the required notice.
Okay, so I'm going to bring in another question now. Joanne Fearon, are you available?
I am, yes. Hi, I'm Joanne, and a HR consultant for numerous companies. And the question I keep getting asked permanently is, if you furlough an employee or employees, can they, so to speak, dip in and out of that? So I've no work at the moment, they may be laid off, but in 2 weeks' time, I might get some work or a contract that I need to do. Can I take them off furlough, back to work, and then if that dries up, furlough them again? Do you know if that's possible?
Yes, that's been a common question, as well as if you have a team of people, do you furlough people for 1 week, bring them back the next and furlough them again?
Yeah.
It looks like, and how I would interpret it at the minute, when somebody is furloughed, that will be it until it's a point in time that the business is saying we now have sufficient work for you to come back, at which case they'll be off furlough, they'll be back as a permanent employee, as it were. Now, it doesn't look, from the information we've been given, if the following week you could put them on furlough again. It may be, I anticipate that the government would put limits on that, but it's not been 100% confirmed yet. Another question that's commonly asked is, if somebody is on furlough leave, can I ask them to do things while they're on furlough leave? Now, what the guidance says, the whole premise and idea behind furloughing workers is that they would have otherwise been laid off, made redundant because of the coronavirus. That realistically means that they are not doing any work at home. But if you need to contact somebody for a question and it's a one-off, it's unlikely that that will matter. But they should not be doing more permanent work at home. They are furloughed.
Yeah, because I've been asked, when companies have temporarily closed and furloughed everybody, what about the lady who does the wages and accounts on a monthly basis? Is she able to do that while she's furloughed?
Realistically, she's still required. So technically, from what we've seen, she wouldn't fit within the definition of being a furloughed worker. She'd have to either be on short-time working, reduced hours, or reduced hours and pay by agreement if there's no short-time working provision within the contract.
Right, okay, thank you.
No problem.
I'm just going to go to a chat question again. This is on a slightly different subject this time. We know 2 people who've been stopped by police asking them if why they were and where they were travelling to, and if they got a letter by their employee that was signed insisting that they go to work. Is there a requirement for a covering letter? If so, how do employers go about getting a covering letter for their employees?
What I've done for clients is that certainly those that satisfy the key worker requirements and are travelling to work still have to go in or need that evidence for the schools, is to draft a letter that is sent by the employer to that individual to confirm they are a key worker and the reasons why. That evidence can then be used, A, if they're questioned why they are travelling and whether it's essential, but be also used for schools, nurseries to say that they need that care and their child still needs to have that school place. If people are going to be asked more regularly by police on why you are travelling, again, the guidance currently states that people can travel to work if they cannot homework. And as good practice by employers, by businesses, if they need somebody to go in, again, a letter to confirm reasons why will be useful.
Okay, just coming back to furlough again, this is a situation that many small business might find themselves in, just making sure that they've done the right thing at the right time. But the question here is, we closed with immediate effect and told all our employees by individual memo that we were furloughing them. They didn't sign to agree, but the employees accepted the situation. Would this suffice?
Again, it's subject to normal employment law and normal employment law principles, so you need their agreement. If you can evidence that through a memo that was issued, everyone has then subsequently gone home, it's fine. It's always best as best practice to get people to sign to confirm their agreement, although I appreciate, and no doubt the tribunals will appreciate, and the courts further down the line, if that is not practicable. So as best practice, get people to sign, and it may be that now, certainly when we get the finer details of the job retention scheme, that you follow it up with a letter, you confirm what the pay arrangements are, when it took effect, and how long it will go on for them to sign in return. So that's what I'd advise in that situation.
Okay, thanks. In terms of, this one's on hourly paid employees. I suppose it's a little bit easier if you're a monthly salary person, but if you've got hours that fluctuate. For hourly paid employees whose hours fluctuate, how do you calculate their pay for April and May while furloughed?
Yeah, it's an area that we need clarification on from the government. Anticipate it'll be linked to how we normally calculate a week's pay under the Employment Rights Act, etc. So I imagine it would be an average over the previous 12 weeks, which is what I would guess. But again, we're waiting for confirmation on that.
Okay, this is one about long-term absenteeism. So if someone is off as long-term absence due to a defined disability and the colleague in their department have been furloughed, how should I approach this?
Yeah, it's a question as well that we're getting quite often. Realistically, they should remain on sick leave because that is the principal reason why they are already off and why they are absent from work. It wouldn't be superseded by furlough leave and that pension scheme. Particularly, there's a string of cases and case law say if they're getting the benefit of any sick pay cover, occupational sick pay cover, or health insurance cover that's covering their wages, they should remain on that. Again, it would depend on the specific circumstances, so I can help that individual if they wanted to contact me after. That's the general principles.
So I think it's a similar question, but I'll just ask one. This is being posed. Can employees classed as vulnerable be furloughed rather than receive SSP?
Grey area, the short answer. If they are a vulnerable, there's two levels. There's those that are at higher risk. So those that are over 70, those that have underlying health conditions, and those that are pregnant. At the moment in time, they're not entitled to SSP. If you didn't have work for them and they would be laid off, made redundant, then they should be on furlough leave. The people that the government are writing to by Sunday, this higher class of vulnerable individuals with serious medical concerns, if they are then off because of that, they're entitled to SSP through the amendment to the regulations that I mentioned earlier on. If you as a business don't have work for them to do and they would be laid off or made redundant again, then at that point they'll be on furlough leave.
It's a point of clarity from earlier. Did you say that furloughed workers can only be those who are auto-enrolled into your pension scheme?
No, so the eligibility at the moment is employees through PAYE. That's the information that we've got to date.
Okay, a more specific one in terms of health again. Have you been asked if you should be self-isolating for 12 weeks if your partner is pregnant?
Again, pregnancy is that higher risk group that they've not been told, and the medical advice, as far as I'm aware at this stage, isn't that those group need to be at home for a period of 12 weeks. And certainly the partner of that individual wouldn't fall within that group either.
Okay, so we're running short on people who want to ask questions themselves. Are there any others? We've gone through a number of chat questions there. Have we got others who would like to ask a question that I've not focused on at this present time? If you have, can you just use the raised hand comment and we'll come to you. So I've got Will Payne, who's the first one to do so. I'm going to unmute you, Will. Are you there?
Yeah, hi, thank you very much. Hi, Ollie. Just
hi,
a
Will.
question. How are you doing? Just a question about what you know about backdating to the 1st of March. I'm assuming that it's 1st of March is the start point for 3 months. But if, for example, we send out letters notifying people that they're on furlough, do you know anything about how far we can backdate that if those letters are going out now?
If the letters are going out now and you are only designating people now to be furlough workers and fallen under the scheme, then how I interpret it is that the reimbursement would only apply from that time. The updating to the 1st of March, I think the government's thinking about that was that they may have had a number of employees that they had already potentially laid off at that point or even made redundant at that point. So the reimbursement would cover that situation. So if you're looking at now to place people under the job retention scheme, do it now. It's likely when you get to the point of putting the information on the HMRC portal, you'll ask for confirmation of the date that they were placed. Ultimately, HMRC will have the right later on to do audits. And if your paperwork doesn't match with what you have then submitted to HMRC, there could be implications of that.
Okay, thanks, Ollie. That's great. Thanks.
No problem.
Okay, so Kathy Coulson. Kathy, you might just need to, oh, there you go. Can you hear
I've done
us?
it. Yes. You talk about the 80% wages. Is that paid from day one, or do you do the statutory guarantee pay first and then the 80%?
As soon as you they're a designated furlough worker, will apply straight away. So there doesn't have to be a week of layoff and them only receiving guarantee pay for that point. The 80% reimbursement will cover from the date that they are placed and designated as a furlough worker.
Right, thank you.
Just go back to the chat. A similar sort of question. Is the £2,500 limit the maximum amount that HMRC will pay an individual, or the amount towards which they will contribute 80%?
That's the limit for each individual.
Okay. So I'm going to go to Philip Day next. Philip, can you hear us? I'm trying to mute you. There you go,
yeah,
Philip.
Hi, good afternoon, Ollie.
Hi, Philip.
Are you well?
Yeah, very good, thanks.
It's a specific question, Ollie. The English Football League have now told us, and as you know, I'm a director at Grimsby Town, have now told us that players can undertake no training activity at least until the 14th of April. However, we do expect that the players will try and keep fit at home so that when football does resume, they will be fit. Could we class these as furloughed players in view of the fact that we've had a directive that they should not undertake any training activity?
Yeah, there'll be many questions, and football's a unique industry in terms of pay, isn't it, and the requirements. And you will be having players that are self-training at home because they either can't get to training grounds, they are closed, and particularly with the Football Association, the EFL guidance that they should not be partaking in any sport at the moment. I'll phone you separately about that one, Philip. That's the short answer.
I thought that would be a hard one. Thanks, Simon. Thanks, Ollie.
Thanks.
Thank you. So we're still looking for, if we've not answered any of your questions, we've still got about 12 minutes of this webinar to go. So please put your hand up if you've got any more. I'll just do a few more just to make sure we've got some time for you to reflect on the questions that we've done. One that I've got from the chat though, just before we go to that, is about current. And now it's kind of moved on me. That's good. Is about. Here we go. Does an employee? Oh, here we go. Would appreciate some guidance on how we appropriately manage accrued and accruing annual leave. I suppose this is about people who are working at home at the moment that might decide that they want to cancel annual leave because they are unable to go on a trip, or they're not able to go out at this time, so they don't feel that they want to take annual leave. There might be a period that comes down the track, depending on where your annual leave year is, that you might not be able to manage that requirement. So what's either best practice or how can an employer process that?
Yeah, so those employees that can continue to work during this time, a business again may be planning for the longer term and thinking realistically, can we afford a budget and do we want people to be on annual leave at this point? And on the flip side, people will no longer be going away on holiday, so may look to be cancelling annual leave. Now, as a business, one, you don't have to agree to grant annual leave, and you can enforce people to take annual leave if you want to try and proactively manage the amount of time that people are taking off throughout the holiday year. Maybe another point about annual leave in these times is those that are on furlough workers, so that they're away from the business. And again, contracts of employment continue during that period that people are designated furlough workers, and they accrue holiday while being furloughed. Now, again, you may have various holiday requests that are made during the furlough leave time, which you can agree to, or you may decline and not allow annual leave during that period. A few considerations to make.
Okay, so I've got a hand up, but it's a written hand up in the chat so far. I'm going to open the mic to Lindsay Linder. Lindsay, can you hear us for a start? And if so, could you just put your question to Ollie?
Yes, I can hear you, thank you. I'm liking to know, please, about our apprentices. We've currently got apprentices who are studying at college. Their college is closed for the moment, but they've got work to do. However, our mechanics bay, as from today, will be closed. So they won't actually have work within our workforce. What do we do in that instance, please?
If it's the case that you've got nothing for them to do, then the same options apply for you really under those circumstances. And Lindsay, if you contact me separately again, then we can go through in a bit more detail on what your options are.
Thank you.
Karen Shepherd, I'm going to do the same for you in terms of just open your mic. You've posed a question, so Just got to find you on the list. Karen, okay. Can you hear us okay, Karen? Hello, Karen. Okay, so I'll read the question that you put. You might be able to join us by unmuting. Mm-hmm. Can you just answer, please? I know you said directors PAYE okay to furlough, and also said PAYE lady is still required, so can't be. What about director employee who has to be payroll even though not doing job in retail shop? Who has done for 6 weeks? Do I payroll in own time at home? Did you pick those bits up, or Karen?
I was reading it as well as you went along, then it moved. Let me just scroll back up to that one. I don't know if this means that this individual has 2 separate jobs. I'll answer it in a way that I interpret it, and then let us know if that's incorrect, Karen. So it may be a case, and what people are coming up for the furlough workers is that they may have 2 separate jobs with 2 separate employers. And they can be furloughed from one or both. It just depends on each business requirements. What we're also finding is that maybe an individual will be furloughed from their usual employer, but they're then looking for other work, perhaps to top up their pay if they're only going to get 80%. And again, it doesn't look like from the guidance that will not be allowed. It looks like they potentially will be able to get a second job, as it were. Hopefully that's answered your question, Karen, but if not, let me know.
There's some more if you just scroll to the chat there as well. Just
okay. I say, she said she'll phone me separately, so that's fine. We can go through that.
Okay, so let's check on the last few questions now. What time is it? 12:54. So we've probably just got time for a couple of further questions. One just to choose there. HMRC. Whoa, they keep moving my time, which is not great. HMRC is advising people they can get paid 80% if in vulnerable worker group. Is this correct?
So again, from the rationale behind the scheme is to protect jobs for the future for those that would have been laid off and made redundant because of coronavirus. So if businesses are submitting vulnerable workers details to HMRC when the portal opens, HMRC may want to ensure that it's because they would have been laid off or there was no work available to them. Purely on the interpretation of the law as I see it at the moment, if those vulnerable people are at home because they're told that they have to self-isolate by the government, then they'll be covered by SSP through that amendment to the SSP regs that I mentioned earlier on.
Okay, we have another hand up. This is John Richmond. John, are you there to ask your question? You're unmuted.
Thanks very much, Simon. Hi, Ollie.
Hi, John.
Just a quick one, and just clarification on the date at which employees have to be employed to be able to be furloughed. I have read, and I'm sure we've all read so much and going around in circles with this, that they had to be on the payroll and paid effectively in February pay, 28th, 29th of February, i.e. that the information may have obviously been passed to HMRC on RTI. But you mentioned earlier that potentially future employees that are due to start, say, on the 1st of April could still be furloughed. Could you just give a bit of clarification on that and what I may have heard, you know, about this 29th of February date? Is that significant or not?
Yeah, I'd also, and clients had contacted me because they had heard the same, that only those that were on payroll at the end of February would only apply to them. But from what I've read, that's incorrect. So it will absolutely cover any employees potentially moving forward as well that haven't started yet. So unless the legislation, when it comes in, hopefully next week, when we get the finer details, states otherwise, it would not have had to be on the payroll at the end of February.
Oh, that's interesting. Can I just sneak an extra one in? And that is, can you furlough in two waves, as it were? You might have a bunch of people that are identified to furlough, let's say as of 1st of April, then 2 weeks later, might be more. I presume that will be okay as far as
Yeah, absolutely. So as a business, you may have a drop in demand that then impacts a number of teams to start off with, that you don't need all of those, so you furlough them. As the situation progresses, that could then impact on other teams that you have. And again, it's just an ongoing review as a business. Do you need that? Is the work that they can be doing? If not, can you make the most of the job retention scheme? Another question that I also get asked a lot is, if we have a team of 10 people, we've only got work for 5 of those, how do we select out of that group? Because remember that normal employment law principles apply. First off, I would recommend that you ask for volunteers to go on to the furlough worker status. So you may get your numbers that you require through that. Alternatively, you're going to be looking at putting together a very quick selection matrix to try and retain the skills that you need to keep the business running while the others can go on furlough leave. Now, a knock-on effect from a relations perspective is that some individuals may not be best pleased that they are sat at work where colleagues who do the same job are at home on 80% pay, and vice versa. Unfortunately, that's just a relations issues, and from a legal sense, as long as you have justification for your selection and use a matrix if you need to, you will have covered yourself.
Super, thank you.
No problem.
Okay, the final person with a hand up at the moment that I can go to is Lizzie. Lizzie, I'm going to unmute you. Hello, Lizzie. Hello, hello. No, I'm going to ask a question myself then. Okay. If someone is furloughed in the main PAYE job at £24,000 per annum, and they also have a self-employed second job earning £8,000 on top, can they claim on both the PAYE furlough scheme and the proposed self-employment scheme as well?
Oh, good. Very good question. We're hoping there'll be an announcement today by the Chancellor, or certainly tomorrow, about the steps that they are putting in place for those that are self-employed, because at the moment there's no financial support that's open to them or help in terms of reimbursement. And it looks like, from an amendment that was tabled in the reading of the bill, that it would be 80% as well, or up to just over £2,900. Now, that question, if somebody has 2 streams of earnings, essentially, so the self-employed as well as PAYE, short answer is that I'm unsure. I don't know. And we'll have to get the detail when it's announced, hopefully next week.
Okay, so spot on 3 o'clock. What I would like to say is, as a huge thank you. Thank you for you guys who have joined us today in this, what has been a new experience. A huge thanks to Ollie. I'm sure you would like me to say that on your behalf, and we are really grateful for your time. I think that's been extremely enlightening. Thank you very much for that. In terms of our ChamberConnect series, we have another webinar tomorrow at 2 o'clock. This is with the British Business Bank on the Corona Business Interruption Loan Scheme. So do join us for that if that is of interest. We will have some more coming up next week. The sort of things that we're looking at covering at the moment are overcoming cash flow challenges, the supply chain, managing stress in teams, and managing remote workers. Just a little reminder, if you want to book on Links Chamber website, links-chamber.co.uk/events. If we haven't covered any of the parts that you wanted to ask today, if you've got more questions, then events@links-chamber.co.uk is the inbox to send them to. We'll make sure they go to Ollie. I think what we'll try and do as well, if there were some questions there that we didn't miss, because there were loads that were sent through and it was difficult to get them all in terms of the stream that came through, we'll look at those later on, and we'll post out some of the answers in some frequently asked questions as well. We will follow up with some further information on an e-shot, and that should be coming out to you very soon. But for now, thank you to Ollie again. Thank you for your participation. We hope you found this really useful. Have a good afternoon. Bye-bye.
Bye.
Thank you.